They thought it would be an easy win. But what happens next is nothing short of a legal masterclass. The courtroom was packed, a stifling, buzzing hive. A mix of eager reporters, wide-eyed legal interns, and curious onlookers filled the gallery, their collective anticipation a palpable weight. Murmurs rippled through the space, a quiet, nervous hum beneath the grand, vaulted ceiling of the courthouse. The air, thick with the scent of aged law books and highly polished wood, carried a heavy aroma, the scent of history, of authority, of judgment. Seated at the defense table, Karoline Leavitt meticulously flipped through her notes, her hands surprisingly steady. Her expression, an unreadable mask. This wasn't her first time arguing a case, but it was the first time she was up against Judge Walter Grayson, a man notorious for his glacial impatience and a condescending attitude that seemed to be magnified tenfold when directed towards young attorneys, especially women. The case itself wasn't particularly sensational. A contract dispute between a mid-sized firm and a former employee claiming wrongful termination. But the opposing counsel, Richard Calloway, was a veteran litigator, a shark in a tailored suit, one who thrived on courtroom theatrics. He was the kind of lawyer who smirked before objecting, who played to the jury even in a bench trial. And today he had an audience. Karoline was acutely aware of the odds stacked against her. She wasn't famous, she wasn't connected, and she certainly wasn't the kind of attorney who made headlines. Yet. What she was, however, was prepared to the teeth. As the bailiff called the courtroom to order, Judge Grayson strode in, his black robe billowing slightly, adding to his already imposing presence. He adjusted his glasses, glancing down at the docket. His gaze flickered, dismissively, to Karoline, then to Calloway, before finally settling back on her, lingering with a palpable sense of doubt. "Counselor Leavitt," he began, the corner of his mouth twitching with a barely suppressed sneer. "I see you're representing the defense today." A polite, controlled nod. "Yes, Your Honor." He let out a slow, drawn-out breath, as if the very act of addressing her was an exercise in extreme exasperation. "Well, let's hope this doesn't turn into a law school seminar, shall we?" A ripple of nervous chuckles snaked through the gallery. Even Calloway grinned, not bothering to hide his amusement, the arrogant glint in his eyes unmistakable. Karoline didn't react. She simply straightened her posture, a steel rod of composure, and waited. Calloway stood first, launching into a smooth, practiced opening statement about fairness, responsibility, and corporate ethics. His voice was steady, authoritative, the kind that could make even the weakest arguments sound compelling, almost hypnotic. He painted his client as a dedicated, hard-working professional, a victim betrayed by a greedy, heartless employer. By the time he finished, he glanced at Karoline with an almost pitying expression, as if she were a child about to recite a poorly memorized school presentation. The judge turned to her, his expression a mixture of boredom and disdain. "Counselor, your response?" Karoline rose, smoothing out her blazer with a deliberate, unhurried movement. Unlike Calloway, she didn't take a dramatic pause. She didn't clear her throat or fumble with papers. She simply spoke, her voice clear and resonant, cutting through the lingering echoes of Calloway's performance. "Your Honor, opposing counsel has presented a compelling narrative. Unfortunately," she paused, letting the word hang in the air, "it's not supported by the facts or the law." The shift was immediate. Calloway's smirk tightened, becoming more of a grimace. Judge Grayson tilted his head slightly, as if only now considering, with profound skepticism, the idea that she might actually have something substantive to say. But there was still doubt in the air. A thick, palpable cloud of it. She could feel it, pressing down on her. She was young, she was female. She was underestimated. A brief, electric silence settled over the courtroom. A moment of stillness before the inevitable reaction. Judge Grayson exhaled heavily through his nose, tapping his gavel lightly against the bench, as if contemplating whether to humor Karoline or dismiss her outright. Ending this charade before it truly began. "Miss Leavitt," he said, folding his hands in front of him, his voice dripping with condescension. "That was quite the opening remark. I assume you have something more than just misplaced confidence to back it up? A murmur, laced with amusement, rippled through the gallery again. A couple of interns smirked at each other, relishing the spectacle. Calloway barely concealed his amusement, shaking his head slowly, as if this entire exercise was a colossal waste of his valuable time. Karoline, however, remained utterly unshaken, a fortress of calm in the storm of their doubt. "Your Honor," she replied evenly, her voice unwavering, "I would never presume that confidence alone could win a case. I prefer facts." The judge let out a short, condescending chuckle, the sound sharp and dismissive in the hushed courtroom. "Well, that's good to hear. I'd hate for this to turn into a motivational speech." More laughter. This time louder, more unrestrained. Karoline ignored it, her focus laser-sharp. She reached for a document in front of her, holding it up with steady hands, her fingers not trembling even slightly. Moss. "If I may, Your Honor, let's talk about Colton v. Redbridge, a case that directly contradicts opposing counsel's claim that the termination in question was unlawful." Calloway let out a quiet, dismissive scoff. "That case doesn't apply here," he said, waving a hand dismissively. "The circumstances are entirely different." Karoline turned her head slightly, meeting his gaze for the first time since the proceedings began, her eyes cool and unwavering. "That's incorrect. The precedent is directly relevant because the ruling hinged on a key factor: the presence of a contractual clause limiting termination discretion, a clause which, I might add, also exists in this case." Calloway blinked, caught off guard for the briefest of moments, a flicker of surprise disrupting his carefully constructed facade of confidence. Judge Grayson's expression remained unchanged, though his fingers tapped idly against the bench. A subtle sign, Karoline knew, that he was at least considering her point, however grudgingly. "Miss Leavitt," the judge said, reclining slightly in his chair, his voice still laced with skepticism. "I appreciate the effort, but do you really think a single precedent overrides the fundamental principles of at-will employment?" There it was, the setup, the trap. He wanted to school her, to publicly humiliate her. Karoline didn't flinch. She flipped through her binder, pulling out another document and holding it up, a silent challenge. "Not a single precedent, Your Honor. 5. Each of them reinforcing the same principle. Employment contracts with clearly defined limitations cannot be dismissed under the at-will doctrine." "Would you like me to list them?" The courtroom quieted. The playful tapping of Judge Grayson's fingers ceased. Calloway's smirk was now noticeably strained, the corners of his mouth pulled tight. Judge Grayson adjusted his glasses, his gaze sharpening. "Well, Miss Leavitt, since you seem so determined to turn this into a law lecture, by all means, educate us." His sarcasm was sharp, honed to a razor's edge, meant to belittle, to diminish. Karoline, however, took it as an invitation, a challenge she was more than ready to meet. She opened her folder, knowing, with a quiet certainty, that what she was about to say would change everything. The playful atmosphere, the expectation of an easy victory for Calloway, was about to shatter. Karoline didn't hesitate. She lifted the first document, her voice steady and deliberate, each word precisely enunciated. "Preston v. Briarwood Technologies, 2014. The court ruled that despite an at-will clause, explicit contractual provisions on termination procedures took precedence." She paused, letting the weight of the precedent sink in. That case was presided over by Judge Holden, who, as you may recall, Your Honor, cited your own opinion in a similar ruling the following year. Judge Grayson stopped tapping his fingers. His expression remained neutral, but Karoline caught the slight narrowing of his eyes, a flicker of awareness, of recognition. She wasn't just quoting any case. She was quoting a case that directly referenced his own judicial philosophy, his own carefully crafted reasoning. A few heads in the gallery turned, whispers exchanged. The mood in the courtroom was shifting, subtly but undeniably, like the slow turning of a tide. Calloway cleared his throat, attempting to regain control. "That's still not comparable. That case involved a severance agreement that wasn't honored, which is entirely different from what we're dealing with here. Karoline didn't even look at him. She simply reached for the next file, her movements calm and efficient. Wells v. Dartmouth Holdings, 2017. No severance agreement, just a termination clause requiring reasonable cause. The employer argued at-will discretion, but the court ruled the contractual obligations supersede the at-will doctrine. She paused again, then continued, her voice gaining strength. That case was cited in Burton v. Advance Corporation, 2019, where the decision reinforced that at-will is not an absolute shield when clear contractual obligations exist. A hush settled over the room, a silence so profound it was almost tangible. Judge Grayson leaned forward slightly, his elbow resting on the bench. He wasn't laughing anymore. He wasn't even smirking. He was listening. Calloway shifted uncomfortably in his seat. He had prepared for a routine argument, one where he could recite the usual legal rhetoric, get a few nods from the judge, and win without much resistance. But Karoline wasn't playing along. She wasn't following the script. She was rewriting it. The judge exhaled, running a hand over his chin, a gesture of contemplation. All right, Miss Leavitt. That's an impressive list of citations. But let's be honest here. Case law can be interpreted in multiple ways. Are you really suggesting that all of these cases eliminate the right of an employer to terminate an employee under the at-will doctrine? This was the moment, the true test. He was engaging now, probing her argument instead of dismissing it outright. Karoline held her ground, her gaze unwavering. No, Your Honor, I'm not arguing that at-will employment is void. I'm arguing that at-will does not override contractual specificity. If a contract explicitly limits termination conditions, then the at-will doctrine doesn't apply unless the language specifically allows for it. And in this case, she turned towards Calloway, looking at him fully for the first time, her voice ringing with quiet authority. The contract states that termination must be based on substantiated cause, with supporting documentation. She paused, letting the question hang in the air, a challenge. Do you have that documentation? The silence was deafening. Calloway's mouth opened, then closed. He shifted his papers, shuffling them uselessly. But Karoline knew the answer before he even spoke. He didn't have it, because it didn't exist. Judge Grayson studied her for a long moment, the patronizing tone completely gone, replaced by something akin to respect. The courtroom's energy had shifted entirely, and for the first time it was undeniably clear. Karoline wasn't just holding her own, she was winning. A palpable silence stretched across the courtroom, thick and heavy. Karoline had done something neither the judge nor Calloway had expected. She had cornered the opposition, not with theatrics, not with overstatement, but with pure, precise, unassailable legal argument. Calloway adjusted his tie, scanning his notes frantically, as if the answer, the magic bullet, would suddenly appear. It wouldn't. Karoline had checked. She had gone through every document, every shred of evidence in the case file before stepping into that courtroom, and she knew, with absolute certainty, that the necessary substantiated cause, the very condition required for termination, wasn't documented anywhere. Judge Grayson exhaled, rubbing his temple, his expression thoughtful. Mr. Calloway, he said finally, his voice measured, devoid of the earlier condescension. Counselor Leavitt has presented a strong argument. Do you have documented evidence to prove the termination met the contractual standard? Calloway hesitated, his mouth pressing into a thin, tight line. He wasn't used to being put on the defensive, to being challenged so directly. Your Honor, he began, his tone still carrying remnants of the confidence he had walked in with, though it was now noticeably frayed. At-will employment is the foundation of employer rights. It exists precisely to prevent disputes like this from clogging the courts. Karoline didn't even wait for the judge to respond. She turned slightly towards the gallery, addressing the room as much as the bench, her voice clear and strong. That's an oversimplification, she countered, her words cutting through Calloway's bluster. At-will employment is a default rule, not an absolute one. The moment an employer adds specific limitations to a contract, they have voluntarily given up blanket at-will discretion. They can't use it when it's convenient and ignore it when it isn't. The judge leaned forward, his gaze intense. So you're saying the company essentially wrote itself into a box? Karoline nodded, her expression unwavering. Precisely. They wrote the rules, and now they're trying to pretend those rules don't apply. The murmurs in the gallery grew louder, more distinct. A few interns exchanged knowing glances. Even the court reporter, who had remained expressionless through years of routine, often tedious cases, looked mildly intrigued, a flicker of interest in her eyes. Calloway's frustration was becoming visible now, his composure cracking. Even if there was no documented reason, the company still have a right to terminate. Karoline turned and faced him. If that were true, why include a clause requiring substantiated cause with supporting documentation? Why go through that effort of drafting a condition if you never had any intention of honoring it? Calloway had no answer. Judge Grayson, who spent the first half of the hearing treating Karoline like a child, now looked at her with new-found consideration. That's a compelling argument, Miss Leavitt. I assume that you have a course of action? Karoline nodded. Yes, Your Honor. Since the termination conditions were not met, my client is entitled to reinstatement or financial compensation for breach of contract. Calloway knew that he lost. For the first time, Karoline knew it too. Judge Grayson looked at her with consideration. Calloway rifled through his papers in a desperate attempt to find something. The judge sighed. Miss Leavitt, I have to admit, I wasn't expecting such a thorough case presentation. Karoline responded. I only deal in thorough, Your Honor. There were chuckles in the gallery, but this time at Calloway. The judge looked at Calloway. Mr. Calloway, your client included a termination clause. Do you have any evidence? Calloway paused. Your Honor, this case is about employer discretion. Grayson raised an eyebrow. Businesses, that's quite a stretch. Calloway continued. Practically, employers cannot be expected to document every personnel decision. Karoline cut in. Except when they agreed to do it. The judge nodded. Miss Leavitt is right. It was over. Karoline had won. Judge Grayson sat for a moment. Calloway was trying to find a way out. Calloway continued. Your Honor, employers will be handcuffed. Judge Grayson chuckled. I fail to see how a company is expected to follow its own contract. The judge turned to Karoline. Miss Leavitt, you have presented one of the best cases that I have ever seen. Karoline thanked the judge. The judge gestured to Calloway. And unfortunately, you have left them with no legal position. The judge sighed. The court finds in favor of the defense. Damages to be determined. The gavel struck. Karoline had done it. The judge still sat, watching Karoline. Miss Leavitt, you will do very well. Just try not to make any other old judges feel stupid along the way. Karoline smiled. I'll do my best, Your Honor. Karoline walked out, steady and confident. She took a breath, the tension gone. She had one, not just the case, but respect. She walked down the hall, hearing the murmurs. They all saw. They saw her dismantle an argument. She walked outside and took a breath of air. Miss Leavitt. Calloway stood, and for a moment neither spoke. You put on quite a show. Karoline nodded. I wasn't performing, I was presenting the law. He shifted. Don't expect all judges to respond well. I don't expect anything. I prepare for everything. Calloway laughed. Karoline texted her client. Case dismissed. Employer is liable. Her client responded. You're incredible, thank you. Karoline smiled. This was it. This was why. The next time, no one would dare laugh. The courtroom drama of Karoline Leavitt, the underestimated young lawyer who outmaneuvered both a condescending judge and a seasoned opponent, offers far more than just a satisfying legal victory. It's a microcosm of life itself, a potent reminder of the principles that lead to success, not just in the legal profession, but in any challenging endeavor. Let's unpack the powerful lessons embedded in her story. 1. The unshakable power of preparation. Karoline's triumph wasn't built on luck or charisma. It was forged in the fires of meticulous preparation. She didn't just understand the case. She mastered it. She anticipated every counterargument, researched every relevant precedent, and knew the details inside and out. This is a universal truth. Thorough preparation is the bedrock of confidence and the key to overcoming obstacles. Whether you're facing a presentation, a negotiation, or a difficult conversation, doing your homework gives you an undeniable edge. 2. Resilience, the art of unwavering composure. Faced with open mockery from Judge Grayson and Calloway's calculated attempts to undermine her, Karoline remained a picture of calm, focused determination. She didn't allow their negativity to derail her. She used it as fuel. This resilience, this ability to maintain composure under pressure, is crucial in any high-stakes situation. It allows you to think clearly, respond strategically, and project an image of strength, even when you feel vulnerable. 3. Challenging assumptions and defying stereotypes. Karoline was underestimated from the moment she walked into the courtroom. She was young, female, and relatively unknown, a perfect target for those who cling to outdated biases. But she refused to be defined by their preconceived notions. She let her knowledge and her unwavering commitment to the law speak for themselves. This is a powerful reminder to never let others' limitations define your potential. 4. The importance of integrity and accountability. The employer in the case lost not because of a legal technicality, but because they failed to honor their own contractual obligations. They tried to bend the rules to have it both ways, and they paid the price. This underscores the fundamental importance of integrity in all our dealings. Our word, our commitments, must be our bond. Accountability is not a burden, it's the foundation of trust and lasting success. 5. Precision over performance. Karoline didn't win with flashy theatrics or emotional appeals. She won with precise, well-reasoned arguments, backed by solid evidence. She understood that true effectiveness lies not in putting on a show, but in delivering substance. This is a valuable lesson in any field. Focus on the core principles, the underlying truth, and let your actions speak louder than any grandstanding. Karoline Leavitt's victory is more than just a courtroom win. It's a blueprint for navigating challenges and achieving success in any aspect of life. It's a testament to the power of preparation, resilience, integrity, and a steadfast belief in oneself. What are your thoughts? Which of Karoline's qualities resonated most with you? Share your insights in the comments below. And if you found this story and analysis inspiring, please subscribe to the channel for more content on law, life lessons, and overcoming adversity.